Sunday night at 10 on PBS North. Lawyers on the Line is brought to you by Falsani, Balmer, Peterson, Quinn, and Beyer. For nearly 40 years, answering the Northland's toughest legal questions, helping you understand where you stand. Falsani, Balmer, Peterson, Quinn, and Beyer.
Good evening and welcome to Lawyers on the Line. I'm Eric Beyer, a partner at the Falsani, Balmer, Peterson, Quinn, and Beyer Law Firm, and this evening's moderator. Tonight's topic is estate planning. Nobody likes to talk about dying, but having the foresight to take steps to protect your loved ones down the road is always a good idea. Here to talk about issues in estate planning, I'm pleased to welcome tonight's panelists: Jake Baker of the Hanft Fride Law Firm, Bridget Brine of the Brine Law Firm, and Steve Nys, a lawyer with Mark Signorelli Law Office. Jake, Bridget, and Steve are ready to answer your questions. Please call 218-788-2844. If that's long distance, call our toll-free number at 1-877-307-8762. Okay, so let's just get right into the most basic question that happens if you don't make any plans for your estate when you die. What happens if you die without a will to your stuff? Jake, you're closest to me, so.
Thank you, Eric. If you die without a will and you have assets that are titled in your name alone, and the combined value of those assets is in excess of $50,000, your estate will need to be probated. And the laws of intestacy, which is a thick set of statutes that our Minnesota legislature put out years ago, will dictate who inherits your assets.
Let's talk real generally. We have a pile of stuff that's in excess of $50,000. Who gets what if let's say, a person dies and they're married and they have children? How does that work?
Well, the laws work pretty much like your family tree. First, it would go to the surviving spouse, and if there's no surviving spouse, then to their children, and then to their children. If you have no surviving children, it goes back up the family tree and to your siblings or your parents. So the laws, if you haven't made any plans, will make the plans for you.
Okay, all right. Let's talk about the $50,000 figure. Steve, what if your assets accumulate together, are in excess of $50,000 and you have no will, how does that technically get divided out among your heirs?
Well, the statutes themselves say, and Bridget just mentioned it, it depends on whether or not your spouse is your first spouse or your second spouse. For example, if it's your second spouse, then there is a statutory limit as to what the second spouse might get.
Okay, how about probate? What does probate mean?
Probate is just a fancy word for to prove. So when you go to the probate court proves the validity of your will. If you don't have a will, then your estate gets administered in the probate court intestate without the will.
Okay.
But probate's only necessary to transfer title. So you have to have things that have a title that need to be transferred. So if you didn't have any of those assets, you wouldn't need to have a probate done. Okay. So not everybody needs a probate.
Okay, so things that don't have a title, or things that have a title, just like property and cars, that kind of thing. Okay. How can one avoid having to go through the court process in probate?
Yeah, probate is a court-supervised process to get assets out of a decedent's or a dead person's name through that person's will or through the statutes of intestacy to that person's heirs. The way to avoid probate is to title your assets jointly with somebody, to have payable on death designations on assets, to have beneficiary designations listed on life insurance policies or retirement accounts, but also real estate now. Minnesota has a transfer on death deed statute that allows you to actually transfer real estate by a transfer on death deed, which can also avoid probate. So the titling of assets is very important. You can also create what's called a revocable living trust and transfer title to assets into the trust, which would also avoid probate.
Okay, all right. That sounds all very complicated. You seem like very calm in answering these, but let's go into a little more detail. To begin with, can somebody draft their own will?
You can. However, there are detailed statutes on what is required in each state. So I think most attorneys would recommend you speak to an attorney about it. There are legal forms that are available in stores and online. However, they might not meet the Minnesota statutes, and you might save money on the front end, but it might cost more in a more expensive probate, or it might not actually accomplish what you're intending to do with your will. So you really should speak to an attorney about drafting a will or a trust.
All right, I don't mean to put anybody on the spot here, but let's give our callers some general idea of what does it cost to talk to a lawyer and get a will, from the low end to, I suppose, the sky's the limit. But Steve, can you give us some general considerations about what it might cost for somebody to have a will drafted? And I'm not talking detail, you don't have to quote hourly rates here or anything like that, but just the considerations.
Well, all I can say is that in my experience, it is always cheaper to do something than it is to do nothing at all. And I have seen a lot of clients come in the door over the years where they'll show up just holding a deed to their parents' house that their father or their mother owned in his or her name alone when she died or he died. And if the parent had come to me beforehand, we could have used a transfer on death deed or created a life estate, something of the sort, and it would have cost, I don't know, $100, $200 to do that work. Probate can easily cost thousands of dollars. So taking some time to plan on the front end always saves time and money in the long run.
Okay, all right. Let's just say somebody has a very simple estate, like they have a house, they have some cars, they have some bank accounts, they want to make sure that it's transferred as easily as possible. Can anybody give me some idea of dollar figures? What are we talking?
Oh, it depends on the circumstances. I would say that,
I'm not going to give up on this question.
I can tell.
Okay,
For very simple estate planning, if your goal is to create a very simple plan that passes assets on from you to your kids or to your spouse, I would say $500 to $750 would be a fair number.
And I'd say most of the attorneys on a simple will, it tends to be on a flat fee basis, that it's not hourly, so you know what you're paying up front, and there might be additional costs for drafting deeds and things like that, but it's generally sort of a package.
Okay.
And it's not just a matter of drafting a will in very simple situations like that, but also powers of attorney for finances and healthcare directives are sometimes even more important than having a will.
And what I find as well is, the discussion is also going to lend itself to, will this avoid probate? Is this going to protect my assets for medical assistance planning purposes? And so, usually you have a discussion about those issues as well.
Okay, all right. And after the initial meeting, whoever's sitting down, you can give the client a pretty good idea, right?
Yep.
All right, so anybody that's thinking about doing it should call one of these professionals, probably get an appointment, and you can give them a pretty good idea pretty early on.
Right.
Okay. All right, we had a bunch of calls actually, so let's get right to that. Question in Minnesota, if similar to what we're talking about, if an adult daughter in Minnesota passes away without a will, what happens to her estate? Not married, no kids, where does it go?
Parents.
Okay, all right. All right. Another question. Does transfer on death on financial accounts and beneficiaries on those financial accounts, do those supersede any directives in a will?
Yes.
Simply put?
Yep.
All right. Here's a question. Somebody might have to explain the basis for this, but what does the stepped up basis, what is it, and does it still apply? Can somebody explain what stepped up basis means?
When a person dies owning, let's say, a piece of real property such as a house, their basis in the property is what they paid for their house, maybe 20, 30, 40 years ago. So if you die owning your house, then you get the step up in basis at death to the date of death value. And so your children who inherit the house have that stepped up basis, your date of death value of the house.
Okay. One of the issues you run into with that is if you transfer title to the house during your life, typically the transferee would take what's called carryover basis. So they'd inherit the same basis that you had when you bought the property. And so what happens is that can trigger a fairly significant capital gain
Okay.
down the road.
All right. Okay, another caller. Wife and spouse own the house, put a house in a daughter's name, and they retained a life estate. What is a life estate, and what does that mean?
You know, a life estate is an ownership interest in the property. So they would own it for their life, and then the remainder, whoever would get it next, I assume it's the children, would own the property after that. But it is a current interest in the property, which I see a lot of that happening, and I think people need to understand there are some risks with doing this, because if somebody goes through a divorce or a bankruptcy, it might suddenly bring mom and dad's property into their current issues.
Okay. All right. How do I make changes, minor ones, in a simple, cheap, and cost-effective way to a will?
Well, you can use what's called a codicil to a will, which is just a fancy way of saying an amendment to a will. That being said, if you have a fairly old will, it may be cheaper to just have a new simple will drafted for you.
And there is something in Minnesota that allows you to do a list for personal property if your will makes that provision for it, that something that doesn't have a title. You want China or something to go to a grandchild. You could make a list, date it, and sign it, and that would actually make that minor change. And
They don't have to go the fancy process of
right.
witnessing.
I've seen people have numbers on the back of pictures and a list to who gets everything, contents of the house.
Okay.
So.
All right. Caller from Grand Marais. Was the Minnesota gift tax repealed, and if so, why?
Yes, it was. I don't have any scientific research as to why, but I can tell you that it was a knee-jerk, last-minute piece of legislation that I think everyone, including the legislators that signed on to it, would say was not very well drafted and did not achieve the intended effect.
Okay. And so prior to this being repealed, if you gifted something to somebody while they're alive, it'd be taxable. Is that basically what it is?
It's a little more complicated than that, but yeah, the thought of gift tax is that, you know, you're allowed to give away only so much of your net worth, subject to sort of these excluded amounts over your lifetime. And if you go over that, then you're subject potentially to some tax.
Okay.
We still have an estate tax, though.
Okay. Let's talk about the estate tax, the death tax. What is it? Who does it apply to, and who should be concerned about having to pay that? Steve?
Well, right now, for 2014, the Minnesota estate tax threshold is $1.2 million. Over the next few years, between now and 2018, it will raise by $200,000 a year to a $2 million threshold. And it's not just the Minnesota estate tax threshold that changed, but also the marginal rates. So this year, the bottom marginal rate, if you have more than $1.2 million, is 9%. Next year, and between 2015 and 2018, and from then on out, the bottom marginal rate will be 10%, and the top marginal rate will be 16%. And it goes up by about 0.8% each year.
Okay, and just to be clear, that means only assets above those thresholds are subject to the tax, and anything below that, there is no estate tax at all, right?
Right.
Okay.
There isn't, you know, between spouses, though, there is an unlimited. There's no
Okay.
taxation between the spouses.
Right.
This is
But it's important to remember that at the Minnesota level, at least, if one spouse dies with $2 million and leaves all of that money to the other spouse in 2014, and then the other spouse dies the very next day, there's no carryover in Minnesota, so there will be an estate tax paid on the second spouse's death.
Okay.
Did you talk about the federal?
No, it's important to remember that the federal estate tax is still around too. So, but Jake, if you know.
Well, I was just going to say that the exclusion for federal estate tax is $5,340,000, and that is portable.
It is.
So you can pass a substantial, I guess, net worth on to others without incurring any federal estate tax. So
Okay.
the laws there are a little more liberal and friendly than Minnesota.
I just seem to recall this big controversy about death tax. I mean, where was that? I mean, it seems this is a very small amount of people that have to be concerned about that.
And
Am I missing
Minnesota's, I
something?
think, is one of the few states that has this tax.
Okay.
So it does affect, you know, if you're where you're going to live, it does have that effect.
Only if you have that kind of money sitting around.
But you have to remember, I mean, you're talking about death benefit for life insurance, retirement accounts, real
House.
property.
Yeah.
Yeah.
You'd be surprised, you know, how
Adds up.
quickly it adds up.
Is there an exclusion for farms, or are farms treated any differently?
Farms and small businesses,
Yep.
yes.
Okay.
Now, it's tough to plan into those exclusions. It's more a matter of whether or not they apply to you as a small business owner or a farm owner.
Okay, all right. Question from a caller. Can you make your own will if it's verified by a notary? Will it hold up in court? Why don't we talk about what technicalities need to be?
Well, you need 2 witnesses,
Okay,
disinterested, over 18.
okay.
Yep. We recommend that it's also notarized, but it's actually not required to have that notary.
Simply has to be witnesses by 2 disinterested parties.
The notarization typically comes in the what's called self-attestation clause, which is an addendum almost to the will, which creates a presumption that you had capacity and there was no undue influence in the signing of the will.
Okay. All right, here's another question from a caller. Is it advisable to sign a home away from children, and when should you do this? Does it affect taxes? I'm not, is there an issue there that I might be missing?
The question was
Yeah.
signing away a home.
Yeah. Apparently they don't want the children to have the home because they believe that there might be some tax consequence to that.
Well, there'd be, you know, you would take the step up or the carryover basis. So in other words, if the parent bought the property for $20,000 in 1940, that theoretically would be the basis that you would inherit. And if you sold it down the road for $100,000, you'd pay capital gains tax on that gain.
Okay.
If it passes through a will or a trust, the child would get a step up in basis to fair market value at date of death, which theoretically would eliminate the capital gains tax.
Okay, all right. A question about durable power of attorney. Are those forms legal if I have 2 witnesses and fill it out?
You don't need 2 witnesses for a power of attorney, but it is important to remember that there is a new statutory short form power of attorney that just went into effect on January 1st of 2014. But typically you only need a notary.
What is
They're
a power
nice
of
to
attorney?
have. It gives somebody the option of who you nominate, that they could sign documents for you. It's just for financial transactions that they can sign if you're unable to do that. Or you could do a closing, a real estate closing. You were out of town, somebody could sign for you.
Okay.
They do, once you die though, you cannot use it.
Okay.
So it's just during your lifetime.
All right. We have somebody must have been watching some movie. I think here's, can you have a video will? Can you have a video will?
A will must be in writing.
Yeah.
Okay, all right. So that's just Hollywood.
Yeah, and I've recently had a question about if you need to do the formal reading,
Yeah, I
and
get
there's
that
no
too.
requirement for that.
Okay.
Yeah.
It's all much more boring in real life, like just
Exactly,
about everything we
yeah.
do as I'm
I have run into circumstances where the signing of a will can be videotaped, and the purpose of that is to create evidence that the person knew what they were doing and had
Capacity.
capacity.
I suppose that could be a good idea.
Well, it can work against you too, because one of the premises is, why do you do this?
If you're
You know,
concerned
yeah,
about.
you obviously have a concern or you wouldn't do it, so it can go both
right.
ways.
Okay. Here's another question. If personal assets are co-owned and one owner dies, does it automatically go to the other owner?
Not necessarily. With real property, for example, if there's a joint tenancy, the surviving joint tenant would be the sole surviving owner of a parcel of property that was owned by 2 people as joint tenants. But if they are owners as tenants in common, the tenancy in common does not carry with it a right of survivorship. And so the heirs of the deceased tenant in common would wind up as the owners of that 1/2 interest.
All right. See, some of these terms are, I've got some flashbacks to studying for the bar exam. I haven't heard them since then. So, well, they're in real life practice now. So it's, what is a revocable trust, and when would one use a revocable trust? From a caller in Duluth. Generally,
Well,
what's a revocable?
Generally, it's a trust that you could change the terms. You can revoke it at
Okay.
any time, make changes to the terms of it. They're quite common.
Okay.
But a trust is only as good as if it's been funded. If there's nothing, it's like an empty cookie jar. If there's nothing in that cookie jar, it's just an empty cookie jar. But if you put things in it, a home, real estate, other assets, then that trust can operate, but it could be changed at any time.
Is there a tax consequence, or why would somebody use a revocable trust versus an ordinary trust?
Irrevocable.
Yeah. Is there?
Well, I mean, one of the things obviously is from a flexibility standpoint, you can revoke it and change it, and circumstances in people's lives change over time, and it's uncomfortable for people typically that I work with to lock themselves into something that can't be changed. And a trust, just very simply is an agreement between a creator of the trust, a grantor, and a trustee. And the trustee manages assets for typically the benefit of the creator, but also sometimes for the benefit of others. The trust sets out the terms of the management of the assets, and the trustee has a fiduciary obligation to follow those terms. So for somebody creating a revocable living trust, it's like sort of creating an alter ego to take ownership of assets, typically for probate avoidance purposes, but also to a certain extent for incapacity planning purposes as well.
Okay.
One thing it's nice to use it for is if you own property in another state.
Yes,
You would
absolutely.
avoid probate in a second state. So your
Absolutely.
cabin in Wisconsin, if you had that in your trust in Minnesota, you'd only be administering that trust on death.
Let's talk about the family cabin. How can somebody keep the family cabin in the family?
Well, there's a number of ways you can do it, and it's generally a decision that a person will make, based on the size of their family, how the family gets along, and sort of their overall asset picture. Some people like to put the cabin in a standalone cabin trust. Some families like to form a limited liability company or a partnership or another business entity to manage the cabin. Or, if there's just one child who tends to do all the work and get most of the benefit from the cabin, you could just give the cabin to that one child and then provide for your other children with other gifts, cash gifts, or trust provisions for them.
Okay, all right. Question from a caller in South Range. I want to set up a foundation through my will and trust. Is that a particularly cumbersome or complicated process?
Yes.
Okay, good enough. Simple answer. Daughter is a beneficiary of my house. If I go into a nursing home, does my daughter still get that home? Nursing home question.
Well, that is fairly complicated as well. With nursing home care, you either private pay or somebody else pays for you, typically medical assistance.
Mm-hmm.
So if you can private pay, you never have to go on medical assistance, and you can pass everything that you're left with on to whoever you want to.
Right.
If you go on medical assistance, there are very stringent rules on what you can own. And even if you own something that doesn't count against you to qualify for medical assistance, the county can keep track of the medical assistance you receive and file a lien or a claim against your estate,
Okay.
which would have priority over inheritance rights.
Okay.
And the person said that the daughter, I think, was a beneficiary of the house. So even if the daughter had the remainder interest and the parent had a life estate in the house, the county could still go after what we now refer to as the zombie life estate, the value of the life estate when the parent dies.
Okay.
And that was a significant change in the law. I think it was maybe 10, 11 years ago now. Life estates used to be extinguished at death, and the county couldn't grab onto anything. And if they were created on or after that law change was enacted, like Steve said, that life estate survives your death. So.
Okay. All right. Question that's asked, caller in Duluth, transfer on death deed for a house. Can you do a transfer on death deed for a house if there's still a mortgage on the house?
Yes.
Yeah. Doesn't affect any mortgages. It doesn't transfer that interest in the home until that death happens.
Okay, and what happens to the mortgage?
Mortgage is still on that property.
You pay it or you lose the house.
Exactly.
All right. Transfer on death, when is it recommendable or recommended?
Transfer on death deed?
Let's assume that's the case. Doesn't say, but I'd say yes. Let's answer that, Wes.
I think it really depends on the situation. Oftentimes, attorneys tend to recommend transfer on death deeds in very small estates when it might not be economically feasible for a client to set up a revocable trust.
If that's really the only probate
If that's
asset.
really the only asset, yeah.
And you don't have like 10 kids.
Right.
Right.
You don't want, too many owners of the property.
That
We've
turns
got,
into a nightmare.
we've got a ton of questions. Quickly, what happens to your Facebook account when you die?
It depends on the terms of service with Facebook or whatever other digital asset or digital service provider you have. Facebook memorializes your account and locks it in.
What's Facebook?
Yeah, right.
That's forever.
All right. Do we have time for another question, or no, we don't? That's all the time we have tonight. Remember, you can watch our show again online at wdsc.org or at our law firm's website, duluthtriallawyers.com. If you have more questions about estate planning, please seek the help of a qualified professional, including our panelists, who would be happy to hear from you. Please join us again when next week we'll be talking about Social Security disability. I'd like to thank our panelists for their expertise this evening, and thank you for watching. I'm Eric Beyer. Good night.
Okay.
Thank you very much. Thank you very much.
Yeah, thanks, Eric. Good job.
Oh, thanks. Thanks. That flies.
Yeah, it does.
It absolutely. The toughest part is trying to figure out what some of these questions are. Yeah, it's like, is there an issue there? Can somebody please jump on that issue?
Who wants to take this one?
Yeah, great. All right. Thanks, guys. I just have to do a quick thing. So. All right. Making a claim for Social Security benefits is not always as easy as it sounds, especially if you get denied. What would you like to know about eligibility requirements, medical evidence, and appeal procedures? Have your questions ready for Lawyers on the Line Thursday night at 7:30 on PBS North. Making a claim for Social Security benefits is not always as easy as it sounds, especially if you get denied. What would you like to know about eligibility requirements, medical evidence, and appeal procedures? Have your questions ready for Lawyers on the Line Thursday night at 7:30 on PBS North.